Alex here with a high conflict child custody video on guardianship. Guardianships can be used in situations involving children or adults, though the circumstances are different. With children, the situation is that they can't take care of themselves in the context of living on their own, paying their own bills, making real life decisions, stuff like that. There's plenty of children out there, 17, 16 years old, who can do these things. They're very mature for their ages, but they are not considered to be free and independent unless they file something known as a petition for emancipation. Most children don't do that. Most children just wait till they turn 18 and just become adults the easy way. The situation for guardianship of adults is trickier. Typically, it involves showing the person to be incapacitated, which has a very specific legal definition in Nevada law. I'm not sure if the other states also define what incapacitated means, but the person, for some reason other than being a minor, which is separate, I mean, that's kind of obviously put into the language because they want that to apply to situations involving adults. The person, for reasons other than being a minor, just can't receive and evaluate information. They can't communicate decisions to the extent that they can't meet their own essential needs. They can't pay their own bills. They can't make their own choices. This typically involves a brain injury or some kind of disability that they're suffering from. When it comes to how I'm going to cover this video, it's tricky because a lot of the issues regarding guardianship aren't necessarily all in the same boat. There's all kinds of different things that become relevant when it comes to guardianship. For example, I guess I'm just going to tackle them as they pop into my head. For example, constitutional principles trigger when you're trying to take a person's right to make their own choices away from them. It's considered a fundamental constitutional right. So if a person doesn't want to be a ward, by the way, I don't know if I mentioned that, the guardian is the person who is making the decisions for the other person who's known as the ward or the protected person. Got off on a tangent there, but I do want to let people know what that definition of protected person or ward is, because I'm going to refer to that in the video. Anyway, if the proposed ward or the proposed protected person doesn't want to be subjected to a guardianship, it's considered such a serious constitutional or such a serious fundamental right in the Constitution to be able to make your own choices that that person, who, if they can't afford an attorney, will be appointed one. Typically, it's a public defender. I'm not sure if other states deal with that differently, but in Nevada, it's either a public defender or an attorney from the guardianship not the guardianship compliance office. I'm going to talk about that later, towards the end of the video. From the public guardian's office. I believe each county has a public guardian. It's one of the two. I'm not sure which. They will get a free attorney, and that attorney will represent them. Another protection that is imposed is that you can't just file a petition for guardianship just because of your own beliefs. You have to attach your own beliefs regarding the other person's incapacitation. Otherwise, we would have an issue of family members trying to exploit other family members through the legal process. You have to have a certificate from a physician or a doctor regarding the proposed ward's incapacitation, whatever it may be. I think I mentioned earlier it could be because of in fact, I'm sure I did, but I did mention it earlier. But the doctor who fills out the certificate and signs it would have to mention that there is some kind of disability, some kind of mental disability, or that the person was injured, traumatic. The person suffered a traumatic brain injury for some reason. That, for some reason, whatever the doctor wants to articulate in the certificate, has affected their ability to make choices for themselves. Whatever particulars will be in the certificate, that has to be attached to the petition and filed. So there's two really strong barriers in place to protect a person from being subjected to a guardianship against their will and basically deprived of all their assets. Because, as I mentioned, I'm going to talk towards the end of the video about some of the things that have happened in Nevada, but I'm not going to go into that right now. I'm going to try and stay on track. So another protection that's in place is the rule. I'm going to call it a rule, but I think it's precedent that goes way back, that even if a judge finds that a person is unable to make their own decisions, the judge has to go further than that. The judge has to determine to what extent And once the judge determines the extent at which that person needs assistance with making their own choices, the judge has to be sure to only empower the guardian with the powers needed to satisfy the proposed ward's incapacitation, whatever it may be. In other words, the court can't just make a finding, yeah, this person's incapacitated, you can have complete and total control over their lives. The court has to go further and investigate to what extent is that person incapacitated, and ensure that only to that extent is the guardianship going to be given power over them. There is another thing I wanted to mention. Apparently there is this notion of guardianship over a person and guardianship over the estate of a person. Apparently the court can impose one or the other or both. Guardianship over the person involves making choices with respect to where the person lives and what kind of things they can eat, who they can contact, who they can talk to, who they can spend time with. Complete and total control over that person's life. Or partial control, as I mentioned previously. The court has to look into whether or not it's appropriate to just give partial control over that person's life. And then with the estate, it's their money, their finances, their real estate, their property, real estate, cars, assets, everything, stocks, whatever they may have. Another few things I wanted to mention. One is that there are laws in place with regards to expenditures that I think are over a certain amount. Big picture expenses. Something like using the proposed ward, or using the ward's money to, let's just assume at this point that the guardianship has been imposed. Using the ward's monies to buy a house to put them in, or to buy them a car, something like that. I believe if it's over a certain amount, the approval of the court must be obtained. I know for certain that gifts are strictly controlled. For example, using a ward's money to buy gifts for other people, especially if it's using the ward's money to buy a gift for the guardian. That's a big red flag right there. There are definitely statutes on that require approval from the court before something like that can occur. So let's see, we talked about their constitutional protections, spending their money on big, the accounting. I want to go into the accounting. There are periodic accountings that must be filed with the court with regards to how the ward's money is being spent. And I'm pretty sure that there's a threshold number in Nevada. I'm not going to go ahead and look into this myself because I want people to do their own research. This video is just to let you know some of the terms, phrases, how guardianship works, give you an idea of what's going on, not give you the exact specific formula as to how to deal with representing yourself in a guardianship proceeding or something. The accounting, or what I was mentioning, is there's a threshold number, and if the ward's assets are valued at higher than that number, the accounting is either handled more strictly, or that's the basis for the accounting, the periodic accounting. I think it's a yearly accounting. And then, of course, if the assets are valued at less than that threshold amount, I wish I could remember for sure. But like I said, the law could change anyway, so it's probably a blessing that I can't remember. There's either no accounting at all, or the accounting is scrutinized a lot less. Maybe it's not required to be filed as often as it would be ordinarily. I wanted to mention that the petitioner, the person who files the petition, doesn't necessarily have to ask the court to impose or to make them the guardian. A person could file a petition and ask the court to have somebody else be the guardian of the proposed ward. Quite often family members won't step up to the plate, and the ward will have a guardian who's either from the public guardian's office, that's a government guardian, or a private guardian. That's a guardian that's being paid money. I think at this point it's good to kind of segue into what I was going to talk about earlier regarding the Guardianship Compliance Office. We have a new agency in Nevada that was created after some serious scandals came out about 4 years ago, I think. And there has been news on it nonstop for the past 4 years at least, regarding guardians who were basically disgraced and fined, sanctioned, sentenced to prison even. I think there was one really recent, maybe yesterday even, that was sentenced to something like 40, 41 years in prison over what they did to their wards. This was a private guardian, was not a family member. Not that family members are perfect either, because there are situations where family members will exploit their ward and do just like what I'm about to say these private guardians did, which is they sold off their assets, their homes, their cars, drained their bank accounts, isolated them from their friends and family, presumably to make it easier to financially exploit them. There are serious concerns when it comes to guardianship in any state, in any country probably. Anytime you're giving one person the authority to make decisions over another person, there's always going to be that potential for abuse there, even though there are statutes that prohibit getting gifts, like, as I mentioned, getting your buying yourself a car or a house out of your ward's monies. It doesn't necessarily mean that a bank or a company is going to step in and prohibit it. What's going to happen is somebody's going to have to eventually figure it out, report it as a crime, and then the guardian is going to have to be removed from the case and potentially subjected to criminal liability. But that's not that great. I mean, after the fact, the money's still gone, and that's kind of the boat that these victims were left in. There were a lot of guardians who were scrutinized and swept up by the Guardianship Compliance Office and whoever else is doing the investigation on these guardians. And it's great that they were found out and that they were removed from their post and that they were fined and put in prison, but the money's still gone. So the wards still have nothing left. It's really sad. Some of the articles that have come out will describe in detail what happened to them, but I wanted to talk about that a little tiny bit. I want to loop back around to guardianship of children just really briefly. I do want to mention that while most of the time guardianship over children is done at the consent of the parents, for whatever reason parents need somebody to take care of their children temporarily, there is a possibility that a child can be subjected to a guardianship against or over the objection of the parents. The same constitutional protections that I mentioned apply, but for this issue, I'd recommend watching my video, Parental Preference Doctrine, which I did really recently, because that doctrine applies in these situations, and it makes it quite difficult to do this over the parents' objections, but not impossible. It can happen. Wanted to mention that in those situations, the attorney that the child would get is probably not going to be from the public defender's office. It's probably going to be from the Child's Attorney Project, which I have a separate video on. It's called Child's Attorney. And I'm not sure if in those situations guardian ad litems get involved. It may be something that happens at the court's discretion, or it may be something that's just mandatory in all guardianship cases. With that being said, I did want to mention that even if a guardianship is imposed, it can at a later date be terminated at the request of some other person, at the request of the guardian, or even at the request of the ward. And I wanted to mention that while the government will foot the bill for wards that don't really have any assets, the situation isn't as good for people who do have assets. It appears to me, from what I've looked at, that attorney fees and expenses do come out of the ward's finances. So if they do have money, it does often end up happening that some of the assets get liquidated to pay for the expenses of the guardian, legitimate expenses, of course. And potentially for attorney fees, anytime a situation arises where there's a dispute between the guardian and the ward, the attorney fees are probably going to come out of the ward's finances. So that's really you know what, there is one more thing I wanted to mention when it came to this, but unfortunately I can't recall. So what I may do is, if it pops into my head later, I may post a comment down in the comments below. If anyone here has any questions regarding guardianship, feel free to post them in the comments below. If anyone here has any experience with guardianship proceedings, whether it's a child or an adult, feel free to post that in the comments below as well. And with that, I will see you guys next time.